All right, this next concept is basically judicial interpretations, and there's two main ones, and we're going to look at judicial restraint and judicial activism. Judicial restraint is where judges try to limit the exercise of their own power. Judges should hesitate to strike down laws unless they are obviously unconstitutional. Uses precedent to keep laws. If the Supreme Court already ruled an issue, that is the most important decision and should be upheld. They also look at other case laws, trial courts, appeals courts, but Supreme Court decisions in the past are very important. And if they've already ruled on an issue and the law was constitutional, then it really, something must be wrong to make it unconstitutional. Judicial activism is the opposite almost. It's when judges substitute their own political opinions for the applicable law, or when judges act like legislatures, legislating from the bench rather than a traditional court. Now we then have, how do we look at the Constitution? We have a strict constructionist and broad constructionist. And this is looking at the Constitution. So strict constructionist interprets the Constitution based on a literal and narrow definition of the language without reference to the differences in conditions when the Constitution was written, in modern conditions and modern inventions and societal changes. You look at the original document language. What did the founders mean? What was said in the Federalist Papers? You look at the original intent. Broad construction, sometimes also called judicial activism, looks at the original document and the intent of the framers' language and expands on that, interprets the language extensively to meet the current standards of human conduct and complexity of society. Something like that would be, broad construction would be, what did basically they had muskets in the colonial times and things are different today. We have AR-15s, we have tanks, we've got different weapons. A strict constructionist looks at the Federalist Papers and looks at what did James Madison or Alexander Hamilton believe about these issues, and then use what they believed without looking at modern day things. Now, to be judicial activism or judicial restraint, that is not the same as Republican Democrat. It's not the same as conservative or liberal. You can have a conservative and a judicial activist, where they do basically use their own political opinions, and they strike down laws and they act like legislators. They create laws. So this is not a liberal conservative thing. This is just judicial restraint and judicial activism. So it's very different than what somebody might say. If you're a conservative, you must believe in restraint, and if you're a liberal, you must believe in activism.